In this video, we're going to be looking at easements. And as academic land lawyers, we need to be able to both categorise rights over land and to ascertain the effects of such rights on a disponee of land. So for example, if Claire has granted various rights over Blackacre, we need to be able to work out what those rights are and whether they bind a disponee of Blackacre, for example, a purchaser of the freehold estate of Blackacre from Claire. So really, the project with these videos is that today we're going to be looking at the first stage right of categorization. So does the right fit within one of the law's rights in round templates? And we're going to finish that off in the next video. And so specifically, we're going to establish the content for which a right must possess if it is to fall within the law's template for an easement within the next couple of videos. And then we're going to look at whether or not the right is legal or equitable, which is a question of formality, in a further video after that. So the content requirements. In the Court of Appeal decision in Re Ellenborough Park, Evershed held that a right amounts to an easement only if it satisfies 4 requirements, which we're going to look at today. In fact, we're going to focus on the 3 requirements, the first 3 requirements, and then we're going to look at the 4th requirement in the next video. So that is, there is a dominant and servient tenement. The dominant and servient owners are different people. The right accommodates the dominant tenement, and the right is capable of forming the subject matter of a grant. Okay, so even if those 4 requirements are ticked off, the right established won't necessarily be an easement. Satisfying these content requirements is necessary but not sufficient for an easement to exist, because in addition, the parties to the right must intend for it to exist as an easement. In other words, intend for the right to be a right in rem. When these 4 requirements are satisfied, the law presumes that intention exists, but it would be perfectly possible for the parties to opt for a right that does satisfy these requirements to exist as a license only, so an in personam right. That can be contrasted with the position of leases. If the content requirements of a lease are satisfied, then the parties will have no option to create an in personam license instead. But this can be explained because there was a desire to prevent people avoiding the Rent Act's legislation, and I discussed this in depth within my leases video. So let's look at these in turn, well, at least the first 3 in turn in this video. So there is a dominant and a servient tenement. So this, in other words, means there must be 2 plots of land, one of which is dominant, the other of which is servient. So the dominant plot of land is the land that has the benefit of the easement, and the servient plot of land is the land that has the burden of the easement. The second rule is that the dominant and servient owners are different people, so the 2 plots of land must be owned by different people. So the first 2 rules, the first 2 criteria when it comes to checking whether or not a right amounts to an easement are pretty straightforward. And given these first two requirements, you can tell that easements belong in the same sort of family as a covenant, in the sense that both the easement and the covenant are rights that burden one plot of land while benefiting another plot of land. And the third requirement is accommodation, so this is going to require a little bit more of a discussion. In order to exist as an easement, a right must accommodate the dominant land. So accommodation demands that the right delivers the benefit to the dominant land, or more precisely, a benefit to the owner of the dominant land in their capacity as owner of the dominant land. But accommodation demands that the right delivers a benefit to the dominant land rather than a mere personal benefit to the dominant owner. As such, the right must, at least in the abstract, apply indifferently to the current owners of the dominant land and his successors in title. So the right cannot just be personal to the person who wishes to have the easement. It cannot be idiosyncratic. It has to benefit the dominant land and thus benefit the successors in title. So rights which have been held to accommodate the dominant land. In Moody and Steggles, the High Court held that the right to hang a sign bearing its name on adjoining premises accommodated the dominant tenement, which was a pub. In Re Ellenborough Park, the Court of Appeal held that the right to use a neighbouring garden accommodated the dominant tenement, a residential property. And in Polo Woods Foundations and Shelton Agar, the High Court held that a right to graze 10 horses on a neighbouring land accommodated the dominant tenement, which was a farm. And what about situations where a right was not held to accommodate the dominant land? In Hill and Tupper in 1863, the owner of the land on the bank of a canal, which was the dominant tenement, claimed that his right to operate boats on the canal, the servient tenement, amounted to a valid easement. The claim was rejected on the basis that the claimant's contractual right to operate boats on the canal did not accommodate the dominant tenement, but instead delivered a merely personal benefit to the claimant. The Re Ellenborough Park gloss. So, in Re Ellenborough Park, Evershed asserted that in order to accommodate the dominant tenement, a right must not only benefit the dominant land, but must also be connected with the normal enjoyment of the property. This means that the meaning of this sort of additional requirement is ambiguous. So it is perhaps unsurprising that it has been interpreted in various different ways in the case law and academic commentary. So because of this, the exact meaning of accommodation has become a little bit muddy. So we're going to have a look at 3 different interpretations now, just to wrap up this third requirement of accommodation. So the first interpretation of connected with the normal enjoyment of the property. The most authentic interpretation of the requirement links the demand for normality to the dominant land, requiring that the right connected with the use to which the dominant land is normally, i.e. usually, put. For example, although, I lecture law by day, at night I am a druid, for example, where I engage in nightly rituals. I realise there is a house for sale just outside of Oxford, and in the garden of which there is a Neolithic henge, which I like and think is exciting. So I buy the house, not with a view to live in it, but because I think it'd be a fantastic place to practice my druidism. Part of the henge is on my land and part of the henge is on my neighbour's land. So I go to my neighbour's and reach an agreement that I can go onto his land during my nightly rituals. Now, clearly that right in some sense is connected with the land, but it does not connect with the use the dominant land is usually put, i.e. this house is normally used for residential accommodation, but I'm using it in a quirky way. So what this first interpretation tells us is that my right to visit the neighbouring land in order to visit part of the henge, not on my land, cannot accommodate my land because the right has to connect not to the use I'm currently putting the land, but to the use the land is normally, i.e. usually put, and that is as a residential house. This does seem to be an authentic interpretation. It is authentic in the sense that it appears to be working out of our initial understanding of what is and should be meant by accommodation. In other words, a right must be relevant to the dominant land in a way that can justify it having in rem effect. So that was our initial launching pad, the initial starting point and understanding of accommodation. This interpretation seems to chime quite well with that, because in the above example, even though my right to this henge isn't relevant to the way the dominant land is currently being used, that current use is completely eccentric. So my right to visit the henge will cease to have any relevance as soon as I sell my land onto someone who uses it in an ordinary way. It would be wrong for the benefit and burden of my right to visit the henge to travel with the land. Okay, so that's interpretation 1. The second interpretation. This interpretation demands not only that the right to connect with the use to which the dominant land is usually put, which is the first interpretation, but also that this use be normal, i.e. ordinary. So for example, even if the dominant land is usually used as a base for Druidism and has been for many centuries, any right connected with this use cannot accommodate the dominant land because this use is not ordinary. This isn't a particularly appealing sort of interpretation because what would amount to ordinary if it's actually been used for Druidism for centuries? And that's why I don't particularly like this interpretation. It's not that appealing to me. And interpretation 3 is a final interpretation links the demand for normality not to the dominant land but to the right asserted, requiring that the right be one which it is useful for the dominant land to have the benefit of. For example, if I too use the dominant land as ordinary residential accommodation, a right to use my neighbour's home cinema cannot accommodate the land, for it is not usual for a residential home to benefit from a home cinema. This interpretation is also problematic and seems fairly unprincipled. On a pure understanding of what accommodation should and does demand, i.e. the right benefit the land, i.e. the right should benefit the land and not the individual, there appears to be no reason to distinguish between extraordinary benefits to land and ordinary benefits to land. They are both benefits to land, so why shouldn't both be able to attach to the land and travel to subsequent owners? And yeah, so I think that probably sums up interpretation 3 actually. So we've got these sort of 3 different interpretations and differing sort of understandings of what is accommodation, and this is the sort of thing that you'd want to dive into if you got faced with a problem question. So we're going to have a look at 2 different problem questions now and how we can use our 3 interpretations of accommodation to answer them. So let's have a look. Blackacre example. Claire is the registered proprietor of Blackacre and Richard the registered proprietor of neighbouring Blueacre. Although Blueacre has in the past been used as ordinary residential accommodation, Richard uses Blueacre as the base for a small commercial enterprise breeding free-range chickens and selling their eggs. Claire agrees with Richard that his chickens can roam over one of Blackacre's fields. Does this right accommodate the dominant tenement Blueacre? So we have 3 interpretations of accommodation. The first interpretation appears to be the most authentic one. This one demands that in order to accommodate the dominant land, the right must connect with the use to which the dominant land is ordinarily put. So here we have Blueacre, the dominant land. The use to which Blueacre is ordinarily put is as an ordinary residential house. So we need to ask whether the right permitting chickens to roam is connected with that ordinary use. And the answer appears to be no. Although this right connects to the use of the land it is currently being put, i.e. a small commercial enterprise breeding chickens, it does not connect with the use to which this property is ordinarily put, i.e. just a house. So on the first interpretation of Ellenborough Park, this right cannot accommodate Blueacre as an easement. Let's have a look at a second example. Claire is the registered proprietor of Blackacre, and Richard the registered proprietor of neighbouring Blueacre. In the grounds of Blackacre is a swimming pool. Claire agrees with Richard that he can use the pool whenever he wishes. Does this right accommodate the dominant tenement Blueacre? So, accommodation is, the right must deliver a benefit to the land rather than to the individual currently living on the land. And in the Ellenborough gloss says that it must connect with the normal enjoyment of the land. So our right here will satisfy the first interpretation of the gloss. Interpretation 2 will also be satisfied, but interpretation 3 will be a struggle to satisfy if we looked at our 3 interpretations of the Ellenborough Park gloss. So in an exam, mention the interpretations And if one interpretation doesn't work, you can criticise it as having no foundation and being unprincipled, and then suggest the preferred interpretation, which is likely to be interpretation 1. Okay, that is the first 3 content requirements of an easement. In the next video, we're going to be looking at the 4th content requirement of an easement, and that is that the right is capable of forming the subject matter of a grant. If you have any questions about this video, please leave a comment below and I'll get straight back to you. Make sure you subscribe to my channel because there'll be new videos every day. Thank you very much for watching.